Hi, I'm Ed Alexander, attorney and founder with Alexander Abramson, a business law firm in Central Florida. Welcome to our Friday mailbag. We've been fielding quite a few questions lately about contract-related issues. And of course, contracts are a very specific area to the contract at issue. And so I think I wanted to boil those down into a couple of things that come up fairly regularly in those questions. I think the primary issue has to do with contracts where one party can't perform because of the current situation. And there's a lot of talk about merger clauses and things like that, and whether a contract's enforceable or not. But the reality is that if you're in business with somebody and you have a contract with them, when something comes up, the most important thing you can do is communicate with them. If you've seen any of my other videos or some of my writings, I have this situation where I say, hey, contracts are for honest people. If there's somebody getting into a contract with you that never intends to follow through, the best the contract can give you is a lawsuit against that person, and I don't think that's a very good remedy at all. Really, what a contract is meant to do is to make sure that everybody's on the same page. Make sure that we all understand what we're obligated to do and what we're going to get for that obligation. And so communication really is the first step in making sure that if there's a problem, we let everybody know what the problem is and we try to resolve that problem. We literally work with people to get that done. And so that, as you're talking to people, you want to be thinking to yourself, okay, what is the way that we can get around this problem? Is it a delay in performance? Is it maybe reduced performance? There's a number of different things, but again, that's very specific to the contract. The thing that I find sometimes happens, though, is if the contract is one where you're required to perform and you can't perform, that sometimes people will put their head in the sand. They don't want to face the music that, hey, there's a problem here and I can't perform. And I can't stress enough how important it is to get out in front of this type of problem, to work with the other party and trying to resolve the issue. Now, sometimes parties won't work with you and then we'll have to deal with that situation. But at least you'll know where you stand rather than hoping that something will come along and fix the problem. Now, one thing that comes up a lot when there is these types of changes is, how do we make sure that the parties agree? Okay, so it's really important that if you decide to make a modification of the contract, whether it be short-term or long-term or whatever, that modification is in writing. If your contract has a provision that typically begins with entire agreement, that's usually the name of it, and we lawyers call that a Berger Clause, that means that really the contract is within the four corners of the document unless we sign something that is an extra document. And if we sign that extra document, we reference the first contract and then we lay out exactly how we're going to agree to change it. Without that agreement, there is no change to the contract. And one party can decide they don't like the deal that they struck verbally and say that it's non-enforceable. A couple things to consider when you're doing this, right, is, hey, is this a one-time change or is this a permanent change? If it's a one-time change, for how long? And I can't stress enough how important it is to be objective here. I looked at a contract where one party was letting the other out of performance as long as the COVID-19 crisis continued. And when I saw what they'd written until this other party was back to normal, open for business in the normal ordinary course. And I looked at that and I said, well, that's not the same thing as giving them a break until COVID-19 is over, because these parties had anticipated that this person would open immediately when the lockdown order was completed. And I asked the question, what happens if that person can't open because they don't have capital, because they don't have employees, because whatever other reason? It all was included in the language that they selected, not the specific COVID-19 lockdown. So that then was changed so that the parties really understood what they were getting into. I mean, ultimately, it's all about objective determination. We don't want it to be something subjective that somebody's going to put their, personal spin on. We want it to be specific about when and if those have to open. So one thing I do want to say is that, hey, look, if you have a question about a contract, about an issue, if something's going on because of the current crisis or lockdown, pandemic, I think that you should feel free to give us a call. We've been helping people. We do short little 15-minute calls just to get you pointed in the right direction. And we're happy to do that. We don't charge anything for those calls. And we want to be a resource for the business community. So please don't hesitate to give us a call. All right, that's our Friday mailbag. I look forward to seeing you next week. Thanks.